Hard to do, so we appreciate it. My name is Sagiv Shiv. I am with the firm of INTLFC Stone. It is a global financial services firm, and I wouldn't want to take up too much time here, so please look us up on the internet, www.intlfcstone.com. And I am joined today by my esteemed colleagues on the panel, Celine, Mike, and Robert. I'll let them introduce themselves, and then we'll kick it off.
Hi everybody, I'm Celine Krausen. I'm the head of the American Intellectual Property offices at Hogan Lovells. We have offices throughout the United States as well as in Mexico. But Hogan Lovells, as you may know, is a global law firm. We have about 2,400 attorneys and about 100 intellectual property attorneys in Germany alone. So I'm very pleased to see you today. I have a technical background in electrical engineering. So I am registered to practice before the U.S. Patent and Trademark Office, as well as I'm a lawyer, and I litigate patent cases and counsel folks in patent matters, due diligence, opinion work, things like that, in a variety of industries.
Mike Wiener, I'm CEO of Electro Healing, and I like innovation, and so as a result of that, I like patents, and I think that entrepreneurs, it's one of the toughest things to learn when you go and start a business. Is the world of patents, not just intellectual property, but patents. Very complicated, so it's very hard, even if you have money, to know how to spend it. So I'm happy to be here to give the startup view.
Hello, my name is Robert Riddle. I'm a partner with the law firm Reed Smith. Reed Smith is also a global law firm, offices here in New York. I'm from the Houston office of Reed Smith. We also have an office in Munich. My practice is also intellectual property, both on the litigation side as well as the prosecution and transactional side.
So thank you. So we'd like to start it off, I'd like to start it off with a bit of a case study to set the tone for this panel. And irrespective of what you have in the program, we like to call this panel, How Not to Die Poor with Your IP. And so the case study is about what is, in my opinion at least, the greatest invention ever in the history of mankind. It changed countries, changed religions, changed societies, caused revolutions. It was invented in Germany about 450 years ago, and is still the most ubiquitous, widely used technology in the world. And if you look around you, you will understand why. I am, of course, talking about the movable type printing press invented by Johannes Gutenberg. And the reason I bring that up, the story up today, is because I'd like the panel to address some of the issues from my case study. One, Mr. Gutenberg invented the printing press and decided to publish his own books. Gutenberg Bible is one you might have heard of. So there was an issue with the business model there. Was he a manufacturer of presses, or was he a publisher? He also, in order to make his press work, had to invent a few other things, like oil-based inks, like the process for casting the type, and a few other inventions along the way. So another issue is an invention in isolation versus concurrent or simultaneous inventions. And lastly, having invented the most, as I said, ubiquitous and profound invention in human history, he went bankrupt. And who ended up with the patent, if not his banker? A certain gentleman by the name of Johann First. And so, having made the invention and having done something that's so material to all of us today, that we use this invention, this 500-year-old invention, even more than we use Facebook, how does one protect one's IP, and how does one actually make money from it? So this is my case study. These are the questions I'd like to pose to the panel. And we'll just go around the horn here. Celine, would you like to start us off?
Sure. I think one of the things we should start with is the issue of what is protectable and how is it best protectable in the States. Sajid said one of the things you all should take away today is, what should you make sure and do, tomorrow from a business perspective. And obviously thinking about ways to protect your intellectual property has got to be on that list. You'll hear a lot about patents today, but we also need to remember that there's trade secret protection in the United States, which is not a formal registration process, but may be suitable for certain types of technology. And then, of course, there's copyright and trademark protection. Copyright more for written works, and trademark protection for slogans and names. On the patent side, the United States patent system has always been very unique. It's recently become perhaps more harmonized with Europe, but one of the things that makes it unique is that software-related inventions, as well as business methods, have been protectable in the States for a long time. But recently, by virtue of Supreme Court rulings and politics and press, there have been questions. Is even software still protectable in the United States? There's a recent Supreme Court ruling by the name of Alice Bank that involved financial-related software inventions. I can tell you that despite what you might hear in the press about whether software or computer-implemented business methods are protectable, it's very important to still consider patent protection and to consider it right up front for software-related inventions. The cases that have come out have been in the financial area, the area of insurance claims, very much business method related, and there are challenges to patent protection there. But I had a German client come to me a week ago with an invention, an innovation that was conducted online, and the primary basis of it was software related. And his question is, should I even consider patent protection given what's going on in the United States with respect to software? My answer to him was absolutely, because one of the things I've seen in counseling startups is if they go too far without considering patent protection or other means of protecting their intellectual property and have an answer for that, their investors and their bankers, that'll be one of the first questions, what have you done to try to protect this intellectual property? So it's very important to consider right up front what one's going to do. It's tempting to say, I'll rely on trade secret protection, I just won't tell anybody. The important thing about that is that trade secrets are only protectable if they're truly secret, if they can't be reverse engineered. Perhaps a chemical manufacturing process may be appropriately protected by trade secrets and one doesn't want to publish it in a patent. But most technology, database-related technologies, patent protection should clearly be considered, and one shouldn't be discouraged about press and discussion about the scope of patent protection in the United States.
So, Mike, you're an entrepreneur, you're an investor in technologies. What do you think? What do you think about the importance of protection? And
Well, the first thing
the
I
cost
would-
of protection.
The first thing I would tell Gutenberg is I think he's got a pretty good idea. I agree with you. The second thing I would know, I spent most of my life thinking in 20th and 21st century times, which includes speed, time to market, and the way we communicate worldwide. Back then, he was in a little different world. But let's assume it was today. We didn't have the book and he invented it. Then that would be where you really want, as you mentioned before we come on a panel, where you really want to have somebody who could help you think through how much money you really needed to protect it, and is it worth protecting? And that's the reason why it doesn't work for me in the 1400s versus now, is I don't know if he would have spent a lot of money if he would have made money on patents, because I'm not sure how quickly his idea caught on and went around the world. You may know, I don't know. But today, the broader you can go for coverage, since you know it's going to catch on. I remember when I worked for Xerox, they had this patent for WYSIWYG and user interface that they never enforced. They also had the patents for laser printing they never enforced. But they did spend the money to protect it. So you not only have to have it, as you were saying earlier, you've got to know what to do with it. So that would be, if I was advising him, I would suggest getting some people who know how to get money and know how to get good patents.
And Robert, can you address this issue of patents in isolation versus patents that either support or enhance or complement the product or compete with it?
Sure. And first, it's not that you like the story because you're a baker and the baker ended up with the patents, right?
I was hoping to avoid that one, but thank you for pointing that out.
Sure. Yeah, the first question I always ask with regard to a patent strategy, whether that be acquiring patents or litigating them, is what is the business strategy? You have to understand in the first instance, how does the business tool of a patent play into the overall business strategy? So it's sometimes more than just one patent, but you often hear the term patent portfolio, and that is very true. You need to have a broad view of what is the patent strategy, what things are protected, and how do they play off each other and feed into the overall business strategy.
And I'd actually like to ask a follow-on question, because as I look around the room, it occurs to me that most of the technology today that we use here today was either funded, invented, or somehow came to be probably 50 years ago. I mean, from cell phones to internet to electricity to everything, to elevators in the building. Everything we use today has actually been around for a really long time. So if you're the owner of a patent, how do you deal with the fact that your product life cycle might be longer than the protection you're getting?
Yeah, it sort of harks on Robert's point, is that typically to protect a business, it's not just one patent. It's a constant, reevaluation of where am I right now, but where's the market headed? In the States, the thought is, and in Europe it's a little different. In Europe, the patents have a tendency to focus on one particular embodiment of a technology. In the States, the trend is typically to try to write patents that are more broadly focused and that cover not only where you are today, but where the market might be in several years. And then there's also the point of taking almost a picket fence approach to protecting the business. As it may not just be the printer, it may be the ink, it may be an arm or a part of the device. It may be other disposables or peripherals that need to be used with the device. And as the patent protection, as products get old, it's not true for software, I guess it's constantly changing, but one always needs to be thinking, where's my business going to be in several years? Where's the market going to be in several years? And update the patent portfolio to try to extend the life of the business. It's particularly important in pharmaceuticals and other life science related inventions, where it can take so long to get through the regulatory process that your patent protection has almost run out by the time you're there. So it's constantly important to think about what new uses might I have, what new innovations, and to update that portfolio. And that's where budgeting and having enough funds to do that comes into play.
So Mike, given that IP protection is an ordinary course of business, do your companies explicitly budget for it? How do you think about it in the course of, or when you're thinking about an early stage investment?
I don't get, for the last 10 years, I haven't gotten involved in any company that didn't have a strong IP base or the potential for it. And what we do as a method of operation is to make sure there's good patent protection, at least pending, before we go around. We build a business case and a patent case, even when there's no money. And then we say, is this worth it? Might this be worth it? It might be worth it. Sometimes we bet on an inventor who hasn't proven the invention yet. So we always think about patents, also trademarks and other forms of intellectual property. Rarely copyright, because it doesn't usually fit, too important, but it could. But then we have to say, okay, so we think this is a great idea, it's a company be worth developing, but we only have $10,000 in the budget. So we found creative ways to get a lot. We like to think we get $100,000 worth of value for 10 with our strategy. It actually, we get it into the patent office, and what we do, and again, this, what I'm describing is not a shared view with everyone in the business. We try and get the most amount of enabling disclosure for the least amount of fees up front, because that lets us extend out over time. The government will give us all of the rights but not all the claims if we do that right. So we found some firms prefer to charge an average of $7,500 to $12,000 per patent. The universities seem to be stuck in that rut. And what we do is select firms who will help us get tremendous enabling disclosures. So in one case, we filed one patent in 2001 with a company I was with. It was 120 pages of specification and 80 exquisite drawings. And we had a little bit of money, so we filed that with 2,000 claims. But only $650 fee, one fee. Now, this is where there may be a lot of upset with your firm. But we had one firm who said, you can't do that. Why not? It's not allowed and you'll upset the patent office. And we had another firm who said, well, if you do that, you'll have to do all this later. We went with that, and that one filing got us 21 patents without one more bit of work. And the government went through it, but no charge to us. They said, listen, we read all of this and all 2,000 claims. You got 21 inventions here. They told us the 21 inventions. Pick which one the 650 was for. And we got to pick. Now the rest, what we did, which was really valuable for our company, was when we started to have some money, which wasn't hurt by the fact that we had the broad disclosure, which probably cost us $30,000. Then every month I would pay the fee, and every month, a few months later, I would have a patent and have a press release, and we just got another patent, another patent. And we were trying to sell to Medtronic or scare them. And 4 years later, we had 74 pending and issued patents. They had 5, and they gave us $11 million for the portfolio.
So that's
For
very
no known infringement.
great advice, thank you. Robert, when do you tell a client not to file or not to pay or to just roll the dice and risk it?
That's a hard one. I don't know that there's any right answer, and as lawyers, you're always reluctant to give business advice. You try to advise so that business decisions can be made, but you don't want to, advise on the business front. That's not what you're not that sort of tool. But I think you do have to balance the likelihood of getting an issued claim through the patent office and the ultimate value of that claim. So, I've told clients before, well, I can get you something out of the patent office, it just may not be very valuable. If you have an extremely narrow claim that doesn't cover the product of interest for the company, then it really doesn't have any value unless there's value in having the ability to just simply state you have a patent. And sometimes that is of value. But you do have to be mindful of what the end goal is as far as, does the claim cover the product, and does it cover it in a broad sense? In some cases it may be okay that it only covers part of the product, or in some cases it may be okay if it covers some other aspect of a product that prevents others from coming into the market. There's a number of ways to look at it, and I think those all have to be parsed, and you have to look at that critically.
I'd like to make a comment about that. So I'm sitting here as a person who was sitting in the back of the room in the 25, 30 years ago, thinking about my first startup and patents. And I can remember that it probably took me 10 years before I really understood what my patent attorney was telling me and trying to give me good advice. And what changed was one of my co-founders of one of the companies we still have was a patent attorney and also a business guy. And he said, he just realized I didn't get it. So he gave me a 2-page, I still have it, and I should have brought it, 2 pages, 1 bullet, like 10 bullets on 2 pages. He says, you need to know this. And that changed everything, because the one thing I didn't realize until I read it, and I didn't know this, and I think most inventors don't know it, only the smart ones, or the ones who paid a lot. And then, listen, every element of a claim must be present in a product in order for there to be infringement. That should be taught in every elementary school, or at least in engineering schools, and we don't even teach patents, which is why our patent system is a mess. We don't teach our citizens what a great deal it is. Wilson Greatbatch, who I was fortunate enough to be in business with, was the inventor of the pacemaker. Not the very first one. The very first one in Sweden short-circuited after 3 hours. The second one, that lasted over a year, and he licensed it to a little broke startup company in Minneapolis whose name was Medtronic in 1960. And I said, how did you know to patent that? You were working on a sheep farm, putting electrodes on sheep hearts. How did you know? He says, I went to Cornell. That was in they told me how to do an invention book, how to get, every page couldn't be released. I had to have 2 signatures and witnesses. They taught us patents. They don't teach it in the United States anymore. You have one person come in for an hour or 2 and try and tell you this complicated world on which intellectual property and invention is based. We don't understand it, which is why we've allowed the entire patent system in the United States to be undermined the last 5 years by politics and PR. I don't mean to go off on a political tangent. It's a fact. But what should we tell the entrepreneur? We should tell the entrepreneur how a patent works and what a claim means so they know whether or not they want to spend $10,000 to get it. And if they understand it, they may know that they need to spend $300,000 to protect the ink and the tools and the plates and the type and the magazines. You go to Mercantile, he also died broke. And that's when you want to get, if you're lucky, a good investment banker and a good patent firm and some good investors and some real money and do it right. And that's what doesn't happen in this country, which is why I'm very upset. It's random who you'll get. And here in New York, a percentage of them are almost criminal.
And I'll just say that it's important, one takeaway is it's really important to get a patent attorney who understands and is focused on your business strategy from a variety of different perspectives. I had a client come to me a week ago, happened to be in the medical device space. What they were permitted, what they were authorized to do on the regulatory side was totally different than what they had gotten their patent claims to. It was a mixed device and drug situation, and the device they had patented, they were not going to be able to get appropriate regulatory. And the patent attorney had been operating with blinders on in a silo. And it's actually quite common to have situations like that. And your patent attorney if they just get you a claim and they don't understand what your business is, there'll be problems.
Amen.
At this point, I'd like to solicit questions from the audience if you have any. Otherwise, we'll just keep doing it this way. But if you do have questions, please, this is for you. Yes, sir.
Will there be new regulation on trade secrets and trade secrets to the federal level?
Yes, I'm not a trade secret expert, but there is movement in that direction. There's some new regulation. And the thinking is that there is going to be more trade secret related activity, certainly in litigation, primarily from employees moving to other companies. But there is a lot of discussion about trade secrets these days, beefing up the protections. A lot of it, as you allude to, is state law, but there is federal law and regulations out there that are being considered. Some of them may have been enacted. So it's an important area, but trade secret protection is tough because, as I said, that if you're not able to keep your secrets secret, which is very difficult to do, you have to set up particular procedures and make sure that you don't have folks coming into your facility without sufficient protections in place. But that being said, it is an area of focus, and there's expected to be more litigation on the trade secret side and more regulations and laws that come into play.
And part of that, of course, is understanding, what is the value proposition from a product point of view. Do the patents cover the product? Are there related patents that play into that overall business? Like in the Gutenberg example, it's not just the printing press, it's also the ink, the paper, all the other ancillary things that may need to be invented and may have to play into the overall business strategy. So it's sometimes more than just one patent, but you often hear the term patent portfolio, and that is very true. You need to have a broad view of what is the patent strategy, what things are protected, and how do they play off each other and feed into the overall business strategy. Now, a function of state law. And the trade secret law is more or less the same paradigm across the states. However, some states bias their laws to stronger protection or less protection, in part depending on the industry. So, for example, in California with the tech industry, you see weaker trade secret protection. In Texas, where you have the energy industry, you see stronger trade secret protection. And I think that will balance over time, but it also bleeds heavily into employment law and the employees switching. We're seeing a lot of trade secret litigation right now in the energy space where technical expertise in one company is moving to another, and then there's always a fight over whether or not they're taking trade secrets with them.
So for me, as an investment banker, yes, sir, sorry, go ahead.
I have a small business based in Philadelphia. My understanding is that interestingly we have in-house engineers and contract engineers. And one issue that I repeatedly run into, and I try and understand this day in and day out, is people that we work with in California won't sign non-competes. And I know this is, sort of, we deal with this unless it's our intellectual property. They're like, well, it doesn't apply in California, state laws.
Let me just repeat the question so everyone can hear it. The question was relating to non-competes and the situation in California where things seem to be a little different. California does not allow non-competes. Is that true? What is the situation?
Sorry, I wasn't finished, but I think the question is, I guess, dealing with that, and then I have no idea what Germany's situation is. So I mean, not protecting our IP around that is something I think we should follow.
All right, Robert.
It's a tough question, but it brings up a great point, which is, a lot of times when there's a dispute, you look back at some of these agreements like this with contract employees or employees and say, wow, really wish they would have had an attorney look at this more or an IP attorney look at it more. There is no straight answer. I think as to the question about Germany or Europe in general versus the US, in Europe, especially with patents, there's more of a paradigm of the company owns the IP view. Whereas in the US, it's always been more a view of the inventor is the individual will own the IP in the first instance, unless there's an obligation to assign it to the company. So I think it's important to look at those agreements and, depending on the state you're operating, it may or may not be enforceable, but certainly you would want to, in those contracts, govern what state law would apply for that particular contract, which would hopefully alleviate some of the issues with
I have a question for Mike, before you go. A question for you.
Okay,
Let me ask you a
just
question.
comment on that, real quick. Yeah. This is the elevator that never ceases to go down deeper. We're on it right now with just this one question. And I tell you how confused it was, and trade secrets, and I've been into the California thing, and if you pay the guy, shouldn't you own it? And if you own it, can he compete? What I found is I'm trying to make this simple for entrepreneurs so they don't have to go to school, get a patent law degree. So one thing, always make sure that your patent prosecutor has had some litigation experience, even if they lost. Because if they're writing patents and they don't know what's happening in the court, patents are probably not going to be very good. Learn claims yourself. And then what I did was I finally found a really experienced patent lawyer who had worked for big companies and also litigated a lot. So I put him on my board and I get a lot of advice.
So I have a question for you, Mike. What happens in the event where you find a very appealing employee, you want to bring him or her aboard, and they refuse to sign a non-compete? Or an assignment of patents, or whatever it is that you want in your...
Don't hire them.
Okay.
Well, that's probably good advice. Don't hire them. But if you want to hire them, then you kind of have to know how to negotiate it. But basically, I've been on both sides. I worked for Xerox. I had to sign everything, even if it had nothing to do with anything that would involve in their business, and I had to go get outside business interest. So I've been through all of that. I think an employee has to assign, or they shouldn't be given money, or a contractor has to assign if they want the money. Otherwise, don't use them. If they want the project, they should do it. If they don't want the project, I'd be very nervous that they want to invent on their own. So find somebody else.
And the reason why they have to assign is just because you pay someone doesn't mean you own their IP. There has to be a written assignment by a developer or a consultant.
Yeah, software.
Certainly, right.
Again, it gets. What you wish you had is enough money to have these people in your company working to make sure you do it all right, and that's the rub. It's expensive to know this. So you always want to have the assignment, but the non-compete is a whole nother story. And again, I don't think you can get a quality answer from a panel, and it's hard to get a quality answer from a lawyer who charges reasonable rates.
So because we're out of time, getting signal here. I guess the advice is, first and foremost, get really good advisors, and then hopefully your life will be a little easier.
Well, as you mentioned, and I think you mentioned, big firms, which have the talent and the breadth, often have a new company, small company, or startup special rate. Always ask for that if you're small. And listen to what they tell you, and if you don't understand, take the time, let them explain, because these little things are the essence of the business side. And you can't afford to go to law school to learn it if you're in business.
So with that, I'd like to thank our panel. I'd like to thank you for your questions and your patience. And, I did get to answer.